Everybody here. All right. Welcome, everyone. I see a lot of people are joining us now for our very informative session here. Wow, look at that number going up. This has been probably our most popular event this year. I'm Doug Blizzard with Catapult. Welcome Bob Sar here. Bob Sar is a managing shareholder with Ogletree Deakins here in Raleigh. As many of you may know, Catapult, formerly CAI and TEA, were partners with Ogletree for, gosh, it's approaching 30 years. And I'm happy or sad to say I've been here for most of those years. So hence the gray hair. So really excited to have him here today. Obviously part of our mission at Catapult, as you know, is really providing confidence to employers to handle HR people issues. And boy, has there never been more of a time now to need some confidence. So whether you're kind of for or against the administration, there's a lot of uncertainty right now, whether it be EEO, AAP, DEI, Doge cuts, nonprofit funding, the list goes on and on and on and on. And again, whether you're for or against it, it is definitely providing some uncertainty on how to handle these things. We're getting a lot of calls to our HR advice team, about, layoffs, furloughs, wage freezes, hiring freezes, how to implement these things. Our customers just told us X. Do I still do affirmative action plans or not? I mean, I'm getting mixed signals. What do I do about that? So we're getting a lot of calls like that, and we're here to help members think through that. So yeah, that's why we're here today. So we're very excited to have Bob here. And a few admin things just before we jump into this. Obviously, we're recording it. We'll send a link out to that later if someone misses it. If you have questions, just put them in the chat. We'll do a Q&A at the end, and if I feel the need to break in, I'll break in if one's really pertinent. Maybe Mike can answer some of them. We'll see. But again, welcome today. Happy to have you here, Bob Sar. Let's get going. How about that?
Hey, good morning, everybody. Doug, thank you for inviting me to speak and arranging for this. For anybody who doesn't know me, I'm in Raleigh. I've been with Ogletree for all those years that Doug said we've worked together, which we have, and that's been great. We're a big labor and employment law firm around the country. We're in Charlotte. We're in all the major markets around the country, but really grew out of the Southeast and have been. I think Raleigh was the fourth office opened up by the firm back a long time ago, over 50 years ago. What we've done in response to the changes in Washington over the past month is, and I'll talk about today, really the changes that have been implemented and the ones that are coming really cross through a bunch of different sections of labor and employment law. And so we've set up kind of a multidisciplinary approach within the firm. So even just within the niche of labor and employment law and all the HR issues that you guys have on your tables, we've found that we need to pull together people from different specialty areas to hit these and address the concerns from clients. So for lack of a better word, we've set up task force. It really differs depending on industry, business line, size, where people are located. There are a lot of different concerns. And I could spend, all day and all tomorrow talking about this and probably not get through everything. But what I've tried to do this morning is boil it down to what I would say are the biggest issues and concerns and what you need to know sort of that I could fit in 1 hour that would be helpful to everybody rather than try and hit everything. So let me move on. Okay. So off to a busy start. Um, People referring to it. I put the word busy there. Off to a busy start. You can call it a lot of different things. It could be exciting, chaotic. Some people would say, other words, depressing. But it's a lot, and we are just 1 month from the inauguration. It's just been a lot going on at that time. Some of these things. There's a count yesterday, 66 executive orders. We'll talk about what executive orders are so that you understand that. Just in the past month, the president has directed the end of birthright citizenship. He's offered mass government employee severance and fired thousands of other employees. A lot of people got termination notices on Friday if they were within probationary periods working at the government. And I've seen wildly disparate numbers on how many people that affects, but it affects a lot of people. He's effectively ended federal affirmative action, dismantled the OFCCP, and has made, a new term called illegal DEI. We'll talk about all those. Within the government agencies and the independent agencies that the government controls and the president has appointment power to, normally when there's a change in administration, you get a new cast of people coming in. That's certainly true here, and President Trump has taken some more extraordinary steps to change personnel within those agencies. He's fired people at the National Labor Relations Board, fired people at the EEOC. We're not going to have pennies anymore. I listened to the Treasury Secretary Scott Bessent talk about that yesterday for a while. We may get rid of nickels too, so we'll see. Canada got rid of pennies a while ago, so we're a little bit behind on that. Of course, he's renamed the Gulf of Mexico to the Gulf of America, and there are at least 74 lawsuits that are out there challenging the actions so far. So busy, yes, it's been very busy. Um, I wanted to initially start out now by saying here are a few things that have changed in the labor and employment world that really don't have anything to do with President Trump. And I just wanted to remind people about these things because given the speed of change and the breadth of change coming out of Washington in the past 30 days, the things that were already changing for 2025, I didn't want to get those confused with what we talk about today. And that was that the federal district court judges in Texas have struck down numerous changes that the prior administration had in place. So, as we all know, the federal salary basis threshold for exempt employees was going to go up to about $44,000 annually. That is on hold. It is still at the 35,568 level right now. I think that's $684 a week or so. The FTC, the Federal Trade Commission, which is an independent agency set up by congressional statute, but an agency of which the president has appointment power to the leadership. There was last year, in fact, the past number of years, there have been a lot of government policymakers talking about how non-competes were becoming viewed with more and more disfavor. And the Federal Trade Commission kind of took the lead on that and issued a policy position saying that basically they viewed all non-competes to be illegal. That didn't change what happens in states, and most of the things that the federal government does, the states can come on and impose heightened regulations. But in any event, the FTC had banned non-competes. That ban was put on hold by a federal district court judge in Texas. The federal government was mandating vaccines for all federal employees. That was put on hold by a judge in Texas. And the Corporate Transparency Act, which was another initiative of an agency which required some pretty I'll say onerous, detailed and onerous reporting of business ownership information to the government that had not been previously required. That was put on hold as well. So you may be thinking, like a lot of folks, well, who are these judges that are able to stop something that was enacted by a duly elected representative of the citizens? Federal district court judges have a very, very important and powerful job. And there are a lot of them. The United States has about 94 federal district court districts. Each district has multiple judges that sit there. I think there are approximately 673 judges across the country, and they've all got tremendous power and tremendous responsibility. From a North Carolina perspective, we have 12 active federal district court judges and 10 more that are on senior status. And senior status is kind of retirement, except that most of these judges are just tremendous public servants and they really don't want to retire. So most of them work in a part-time capacity. That job is a lifetime appointment. It's someone who, if you hold that position, you were appointed by the President of the United States, and then your nomination was confirmed by the United States Senate. And so it's a big job. I also wanted to mention that because with 74 lawsuits challenging the Trump administration's actions, that's the body of judges that will be deciding those challenges and challenges to any sort of other administrative regulatory decisions that are pronounced. So the basic agenda I want to follow today with that context as a background is I'm going to talk about the federal agency changes. We're accustomed to changes at the agencies with every new presidential administration that comes in. Um, I want to try and help you make sense of the new legal requirements. And a lot of these are coming from the Department of Justice, the executive orders that have been passed, and then looking at or not passed, issued. The executive orders just get issued by the president. And then, looking at what the agencies are doing. And then finally, I want to identify actions that I would recommend, in fact, our firms recommend, and it's not just me, that employers should be taking a look at, sort of the things that could comprise what is on your to-do list moving forward. Um, okay, let's talk about sort of the primary federal um, labor and employment regulatory bodies that are out there. So that's all their logos. You've got the Federal Trade Commission on the starting at the top left, Federal Trade Commission, then the Equal Employment Opportunity Commission, then the Department of Labor and the National Labor Relations Board. Um, the Department of Labor is the cabinet level body of these agencies. That means that it's operated by a secretary of labor. It's currently operated by Vince McConey, is the acting Secretary of Labor. He's a career federal employee that's been at the Department of Labor for a long time. And then there's a nominee by President Trump to become the new Secretary of Labor, and that's Lori Chavez, excuse me. Ms. Chavez is the former Republican Congresswoman from Oregon. And in fact, she had her Senate committee hearing was yesterday, and by the news accounts, I didn't watch it, but the news accounts are that she did very well. Um, so I think she'll probably be confirmed like most of the other nominees. The interesting thing about Ms. Chavez's nomination is that she has historically been a pro-union supporter. So I think you'll see that perhaps some Republicans will be opposing her nomination. Like Rand Paul indicated that he would do that. And there'll probably be some others, but she'll get bipartisan support, I believe, in her confirmation for that job. The three other agencies are independent agencies. That means they were set up by Congress. They're not cabinet level bodies. They're not directly controlled by the president, but instead the president appoints the leaders of each of those bodies. So generally they're called commissioners and they serve staggered terms of service. So that's part of what, when each administration comes in, they kind of get to appoint their new people. And then over time, in most presidential administrations, they'll get more of their own people on there. It's usually an odd number of commissioners so that you can have a true majority vote on things. And that's where the other three agencies fit right now. They're right in the personnel movement time period. You may be wondering, well, why didn't he put ICE up there? Why isn't Immigration, Customs, and Enforcement up there? There's a lot of news with what they're doing. Well, that's because it's part of the Department of Homeland Security. That's actually a department within a cabinet level agency. Same thing with OSHA. There's a lot new with OSHA, but that's part of the Department of Labor. It's not a separate independent agency. So a little bit of detail, and I don't want to hit this in super big detail because there are more important things to talk about. But look about who the people are, because I do think it's important to know the personnel at each of these independent agencies. The National Labor Relations Board, their job is to enforce the National Labor Relations Act. Um, it's got an entire enforcement system built into that agency. This is all about organized labor law. It's about unions. And there have been big changes over the past number of years. The Biden administration was very outwardly facing pro-union, very aggressively pro-union with the National Labor Relations Board and the appointments that were made to that agency by the Biden administration. And indeed, there's been a resurgence in union activity after years of declining memberships around the country. We just had a big union vote in Raleigh last week at an Amazon facility. The union lost, but they got a fair number of votes. Well, President Trump has now fired several of the commissioners, and he's also fired the general counsel at the National Labor Relations Board. All of those jobs are ones that a president has to nominate, the Senate has to confirm, and then the appointment is for 4-year terms. Um, it is controversial in what President Trump has done in the sense that uh, prior to President Biden, none of the presidents had actually fired the general counsel of the National Labor Relations Board. But President Biden did that to the prior general counsel who had been appointed by President Trump 1.0. And so now President Trump has done the same thing that President Biden did, but he's also fired a member of the board, which I don't think had ever been done before. Interestingly, there are two Democratic members on the board. He only fired one of them. He left the other one in place. The bottom line is the National Labor Relations Board needs 3 members to conduct business. That's a quorum for the board to do something. They only have 2 now. So what does that mean other than you can see there's probably some stalemate there on the board level side. Uh, well, the National Labor Relations Board has really led in enforcement and on-the-ground activity. If you've faced unfair labor practice charges or a union campaign, you understand that the general counsel, the top lawyer there in the agency, is the person who really leads and directs enforcement. They usually issue written statements of policy on how to interpret the National Labor Relations Act. The prior general counsel certainly issued many. You've seen over the past couple of years that I've got, the short-term changes. The prior general counsel had said that non-competes amounted to unfair labor practices. That there would be consequential monetary damages for unfair labor practices, that settlement agreement remedies existed for unfair labor practices, so that confidentiality agreements could amount to unfair labor practices. There was an awful lot of sort of pushing a policy in a more labor-friendly manner. I think we will see. In fact, we saw Friday the acting general counsel rescinded a lot of those statements of policy, and there'll be more of that. So, going forward, the board is the only body of the National Labor Relations Board that can actually issue final rules and rule on cases, individual disputes. They issue written opinions about those. But we expect to see a lot of changes in the area of work rules and handbooks and confidentiality agreements. The non-compete issue is going to be dead in the water. That's not going to be a labor issue any longer. Independent contractor tests are likely to be revised. The National Labor Relations Board under the Biden administration had taken a very expansive view regarding who could be an employee, and I think that'll probably be retrenched a little bit. But we'll have to wait and see. Because I think while the National Labor Relations Board doesn't work for the U.S. Department of Labor, let me switch to the Department of Labor. The person who's going to be the Secretary of Labor has got a history of being very, very supportive of unions. I think she was a co-sponsor in Congress of the PRO Act. The PRO Act was a very progressive, union-friendly legislation that was going through Congress but did not end up getting passed. It basically made it easier for unions to organize workplaces. So there's a lot there that's going on with those two agencies. And it might be interesting to sort of see a Secretary of Labor that's more union friendly than the National Labor Relations Board. It would usually be the other way around, but we'll see. So what should you look for? Right now, I mentioned the judge in Texas who had stopped the salary basis level from being increased. That's on appeal right now. The Secretary of Labor certainly may decide to abandon that appeal. That's a common thing that new leaders do when they come into the government agencies. One way to implement policy is to simply stop the legal process that's already in place with the agencies. Um, and I've identified some other ones there that'll probably be issues and areas for you to watch. The EEOC has, of course, got a change in leadership also. Trump fired 2 of the 3 Democrat commissioners. One was the chair. A firing of those people is unprecedented. One of them has indicated that she has retained attorneys, but there hasn't been a lawsuit filed yet to my knowledge. Um, I think we'll talk about this in some of the executive orders and what the Department of Justice is doing. I think all that will sort of fit in lockstep with what the EEOC will do, which is I think they're going to change their direction on a lot of enforcement, a lot of things that they would consider to be discrimination going forward. They're probably not going to consider it to be discrimination or harassment. The Federal Trade Commission is the final one of these independent agencies that I want to call out to you. And that's really because the FTC had been focusing extremely strongly and extremely publicly on non-compete agreements, like I mentioned. That was really driven, I think most people would agree, by the former chair, Lena Khan. Um, she was a Yale lawyer, and as is Vance, and she was pushing that any sort of non-compete agreement would violate, make create an uncompetitive environment, and so she issued some opinions that would just be banned throughout the country in her view. She's gone. That's gonna change. But there were a lot of things at the FTC they're going to change as well. She had been a real You've noticed over the past 4 years, there hasn't been a whole lot of merger and acquisition activity relating to public companies. That was largely due to statements and enforcement positions that Lena Khan took regarding some early mergers in the Biden administration. And so the business has just stopped doing that. I think they'll be with her leaving. I think it will go back to maybe a more capitalist business environment in terms of public mergers and acquisitions, and there'll probably be some. Okay, let's turn now to what the president and the agencies have been saying and doing in the last 30 days that directly impact employers. And I think I'll tell you, it's confusing because there's more going on now than has been done in the past. Um, the way that I try to process this, I want you to understand that there are a couple different lenses to look at these things on because each executive order that comes out only has certain legal impact. It's a defined territory, a defined lane that it operates in. And so you've got to decide, first of all, am I in that lane that's going to be impacted? And then you've got to look ahead to say, what's the trickle down impact of that lane of enforcement on my business? So let's back up one step. And in making sense of these executive orders and policy pronouncements, we've got to remember, first of all, that they're not existing congressionally passed laws. Okay. So I've got on here my lens number one is, of course, all of us have to have to comply with the existing law. So existing anti-discrimination laws, Title VII, Section 1981, Section 503 of the Rehabilitation Act, the Equal Employment Opportunity laws, the case law. That's our established tried and true traditional area of law to look to on how we need to assess our rights and responsibilities as employers and what the rights and responsibilities of employees are in turn. The second lens to look at is think about what the federal government's administration priorities and agenda are. So the things that the president did on that slide where I showed President Trump's picture, the defining and redefining of certain terms, the idea that now there is illegal, unlawful DEI, DEIA, and enforcement paradigm. So that's the second category. And then the third category, I think you've got to look at when you're deciding what action you need to take. You've got to think about the public relations aspect for your business with your customers and your partners, and then your employee relations aspect. So let's think about all three of those lenses as we go forward now and talk about this. Okay. Um, I think you've also got to realize that how you're impacted really depends on the business and industry that you're in, right? So if you receive federal funds, if you're a contractor or a grantee, if you've got money being received from the federal government in any direct or indirect way, uh, you're probably covered by some of these executive orders, if not all of them. It really depends on the industry you're in. You've got to see what organizational type you are. Are you a federally chartered or licensed organization, the banking industry, the nuclear industry, highly regulated industries like that, well, then you've got more exposure than an independent private business, like my law firm, for example. Um, are you profit or nonprofit? Where's that money coming from? And does that mean you're covered by some of these executive orders? There's an awful lot of focus is on sports and really the gender issues in sports. And there's an awful lot of focus on educational institutions right now by some of these orders. I think that's sort of the public square that some of these culture issues are rising from, or just issues that the executive orders are addressing. Of course, are you in a target industry for some reason? One of those, even if you're not getting federal money. Um, the state and local laws still apply. You've got to think about those. So I mentioned earlier, and I'll talk about it, the OSCCP, the underlying legal authority for what the OSCCP does has really been gutted. But there are 20 or more states that have independent AAP rules, really OFCCP type obligations. So it gets rid of the federal obligation pretty much right now, but not the state law obligations. And then think about the case law that's there. Um, the executive orders, the 66 since Inauguration Day. We're 1 month from Inauguration Day right now. Uh, every American president has issued at least one. I mean, every single American president has issued an executive order. Um, totals more than 13,731 executive orders. Okay, so, you know, President Trump's 66 are a lot, and they're coming quick, but there are a lot that have been issued before then. Um, it's confusing because when we hear media reports of changes made by executive order or executive orders that are coming, the media doesn't really explain what the document it is, explain any of the technical details, such as the whys or the hows, and they kind of come across as being instant law as a result, and they're steeped in controversy for that reason. So I want everybody to understand what an executive order is. An executive order is a signed, written, and published directive from the President of the United States that manages operations of the federal government. So it's a direction to the government that the president manages. They're numbered consecutively. So executive orders may be referenced by their assigned number or their topics. So they come up with kind of shortened words for each one of them, oftentimes. Um, Other presidential documents, sometimes similar to executive orders in their format, their formality and issue, but they have different purposes. So they're presidential proclamations, which are also signed and numbered consecutively, and that communicates information about holidays, ceremonies, things like that. There are also administrative orders, which are memos and notices and letters and messages that aren't numbered, but they're still signed by the president, and they're used to manage administrative matters of the federal government. All three types of those presidential documents, the executive orders, the proclamations, and administrative orders, they're all published in the Federal Register, which is the daily journal of the federal government that's published to inform the public about federal regulations and actions. So they're all there. Importantly, remember, executive orders are not legislation. They don't require any approval from Congress, and Congress can't simply overturn them. Congress can pass legislation to make executive orders difficult to carry out or even impossible, such as by removing funding, but only a sitting U.S. president can overturn an executive order by issuing another executive order to that effect. So let me call out the ones on the slide here. The first one I put there is EO 14148, which basically rescinds a bunch of executive orders from the Biden administration. And as you can imagine, it's kind of like there's a domino effect on these. So the Biden administration had done the same thing to Trump 1. Trump 1 had done the same thing to the Obama administration. The Obama had done the same thing to the George W. Bush administration, and so on and so forth. That's sort of standard fare. They come in and say, "I'm going to get rid of everything my predecessor's done. I'm going to issue my own." Um, but then you have things like Executive Order 14151. And this one, it's called Ending Radical and Wasteful Government DEI Programs and Preferencing. And what it does is it directs the Office of Management and Budget to terminate all mandates, policies, programs, preferences, and activities. That's a wide group of things relating to diversity, equity, inclusion, and accessibility. Um, I have had smart people tell me that if you want to take a look at perhaps what is coming along this line, take a look at things that are included in the Heritage Foundation materials. And okay, the political season, they're referring to this as Project 2025. It's like a 750-page booklet of really wonky policy things. But some of the other things that are highlighted in that, I'm told, are things like EEO reporting. That's something that you may expect to see an executive order on dismantling that. Something, taking the Department of Labor and the Department of Justice and stopping the government from pursuing claims under discrimination law for disparate impact liability. That's something that's heavily under attack. All right, so you've got this order telling the government to end radical and wasteful DEI programs. And then I thought I would show you that, of course, that applies to the government agencies, but then applies to any business that those agencies fund. So here is a letter that one of our clients got January 29th, directing them to immediately terminate to the maximum extent all programs, personnel, activities, and contracts promoting, excuse me, diversity, equity, and inclusion at every level and activity, regardless of your location or the citizenship of the employees or contractors that are supported with funds from this award. Any vestige, remnant, or renamed piece of DEI programs funded by the U.S. government under this award are immediately, completely, and permanently terminated. So you get something like that, of course, you've got to act immediately, and you've got to first figure out what that means. I'll talk about that in a little bit too. But let me skip here now to kind of the next big executive order that's gotten a lot of attention. And this is really sports and bathroom type stuff, I think. In President Trump's inauguration speech, he said that there's binary gender only. He said it will henceforth be the official policy of the United States government. There are only two genders. I think what we can expect from that is that there was OSHA guidance about a guide to restroom access for transgender workers. That if that hasn't been revoked already, I'm sure it's just on the list of things that will be revoked. Um, I think they're going to be letters demanding investigation into inconsistent employer policies or benefits. Here. It's just there's a lot to it, but the bottom line is anything that exists out there within the control of the federal government that refers to gender ideology or sex-based rights. The position of the United States government right now is you're either male or female, and there's nothing in between. Clients are getting letters on that issue too. Here's one that a client received. I think they had 48 hours to give a response to this. So think about like businesses in this is Health and Human Services. Think about grant recipients, research universities, anybody doing big business with the agencies of the government are getting letters like this. You must immediately terminate to the maximum extent all programs, personnel, activities, or contracts promoting or inculcating gender ideology at every level and activity, regardless of your location. It's got the same language from the prior letter. So you've immediately got to take action if you've got that letter. What are the other big ones that have come down the pipe so far? Well, there were executive orders revoked, like I said. They're dealing with environmental justice, with DEI in the federal workforce, sexual orientation, and gender protections from the prior administration. Executive Order 11246. That was an executive order signed by President Lyndon Baines Johnson. Been around for a long time, obviously, but it had created affirmative action obligations for women and minorities. It's gone. That's been revoked. It really guts the Office of Federal Contractor Compliance and Programs, which has then in turn been ordered by the acting Secretary of Labor to cease and desist all audit activity. So if you were facing an audit, that audit's going away. In fact, on January 31st is when I've seen the letters going out closing audits to employers. So you say, oh, okay, that means I have no further affirmative action obligations and I can just stand down from those projects. Not true. There are over 20 states with similar laws, so it actually creates a more complicated scheme for us to try and comply with because the state laws, of course, aren't the same. At least the federal law was one law that covered everything. States have different laws. The interestingly, executive order carved out a portion of the OFCC responsibility. It carved out its responsibility to enforce the Vietnam era Veterans Readjustment Assistance Act and Section 503 of the Rehabilitation Act for disabilities. So the affirmative action type obligations relating to Vietnam vets and relating to disabled individuals still exist. Now, it also, that executive order took away a lot of OFCCP authority and responsibilities. But then it went on and added a layer of obligations that are substantial for businesses going forward. So let me tell you about that. Um, Under this, I've got the slide. Read that while I'm talking, and we'll cover both these in one swoop. Organizations doing business with the federal government now have obligations to certify that they do not operate any programs promoting diversity, equity, and inclusion that violate any applicable federal anti-discrimination laws. Those organizations must also agree that their compliance with all federal non-discrimination laws and any contract, subcontract, or grant, they must certify that that is a material term. And that's important because a material term is enforceable under the Federal False Claims Act. I'll explain that in a minute and unpack it. Okay. Some of you may say, gosh, I kind of remember something like this happening in the past, and it's true. Under the Obama administration, there was an order in 2014 that required government contractors and suppliers and recipients of grants to sign a similar order, but it was limited to 14 laws. So the consequence of this is if you get the letter and you're going to have a new contract with the government, you're going to have to agree to these terms. And if you don't agree to those terms, there's new legal liability that's been created, new financial liability, and ongoing business liability, because the consequence of it being a material term means that the government could come in, determine that you're not complying with this broad certification obligation. And if you're not in compliance, they don't have to pay you for work that's planned, work that you're doing, or work that you have already done. So it's very sweeping in terms of the impact. Defense industry clients are getting 48 hours notice on this, and then they've got to certify. You can't, I don't think you can do that flippantly. I think to certify something in a contract like this, you've got a duty to inquire if you're in compliance, if you can certify. I don't think it's something where you can just sign it and say, "Hey, we're just going to do the best we can." There's too much at risk here if you do that. So I think there's a duty to inquire, and my strong advice is that inquiry be conducted under the attorney-client privilege somehow. Um, so that's a lot of what we're helping people with. And that sort of falls under the thing that we don't know what we're going to find until you look. And if you look, you may find things that you don't want to have to affirmatively disclose. And that's where the attorney-client privilege comes in and becomes important. Um, that False Claims Act liability that I mentioned, it really is significant. It covers misspent money. Oh, these certifications also impose a key tam obligation. Key tam is kind of like the California PAGA claims. It's a way for a private citizen to basically step in the shoes of the attorney general and file lawsuits and recover damages and recover fees for it. It creates whistleblower liability for you've made this certification and now any whether it's a disgruntled employee, don't even have to be disgruntled. I didn't mean to say that. An employee, a customer, a public citizen can all raise a hand and say they're not complying with the certification here, and I'm asserting my rights as a whistleblower. I point out that the Department of Justice last year recovered $2.9 billion from employers. Um, I believe they expect that number to go up. Um, so it's a lot.
Hey, Bob, real quick question there. Is that just
Yeah.
for new contracts or does it also cover existing contracts?
I think you're going in and going in and modifying contracts as well. Yeah. Okay, so uh, let's see. Yeah, here, look at this slide where it's got material in every federal contract or award. So if there's a new payment that's going to come in, that term will be there. And I guess to back up, if you've got an existing contract that's not modified, they've got the right to come in and modify it probably, or at least they will assert that right. We'll have to see how that carries out. You're going to have to certify material compliance. You're going to have to certify that you're not operating DEI programs that violate anti-discrimination laws. Uh, you've got the updates to SAM. That's the system for award management. So that's the government system for government contracting. FAR, that's federal acquisition regulations. Those are the procurement rules of the government. They're all being updated to harmonize with the new directions from the government. I've kind of spelled out the risks here, and I did this because I just think there are a lot of risks that you've got now if you're in any sort of trickle down stream from government funds. And so I wanted to highlight these liabilities. Just I've talked about most of them, though. I didn't talk about criminal enforcement risk, but that's there. So we normally don't talk about criminal violations when we're thinking about our business, labor, and employment liabilities, but I think there is one now. And there have been some in the past, but I think this is a broader one going forward. Okay, so now that's the government side. But let's think about, so that's anybody getting that trickle down money from the government, directly contracting with the government, grant recipients, research universities, defense contractors, all that, DOT. Let's think about pure private sector businesses, uh, like our law firm, like Catapult, like anybody else. Executive Order 14173 encourages the private sector to end illegal discrimination and preferences, including DEI. It directs the agency heads of the government to take action to advance this initiative in the private sector. Um, I put here a policy of individual initiative, excellent hard work. That's being referred to a lot as a meritocracy focus. So instead of focusing on uh, diversity, equity, inclusion, focus on meritocracy is the statement about the policy directive behind the government. By May 21, each government agency and OMB and the Attorney General is to submit a report to the Assistant to the President for Domestic Policy, providing recommendations for enforcement of federal civil rights laws and encouraging the private sector to end illegal discrimination and preferences, end DEI. Um, so in trying to figure out what this means and what the future holds for us, of course, we could say, well, just wait for 90, 120 days and then we're going to know. But that's going to make it awfully hard to react to it if we sit on our hands for the next 4 months waiting to see what happens. Because I think there are going to be sweeping changes that a lot of businesses are going to decide they need to make. I think we can look at a couple different sources to see what's going to be required. One would be look at what the government agencies are doing internally, right? So think about it. If you're running your government agency and these are the things that you're doing because the president's directed you to, I'll bet you're going to find that the businesses that you're charged with regulating and driving to compliance with this are going to be required to do very similar things somehow. So I looked at the kind of the strategic enforcement plan with with the government agencies. Very, very interesting that they've identified strategic concerns, and they're going to look at the most egregious and discriminatory DEI practitioners within their sector. But the order as is directs every federal agency to identify 9 employers to pursue for civil compliance investigations. There are over 400 such government agencies. If each of those 400 federal agencies identifies 9, that means there are at least 3,600 businesses that are going to be specifically targeted in this area as the first tranche of enforcement activity. And I think you've really got to think this. A lot of most businesses have put in place extensive DEI programs, planning, and personnel. And we've got to ask the question: is this going to be an anti-DEI focus, or is it an anti-illegal DEI focus? Let me break that down and try to convey the distinction that I'm trying to make here. There's nothing illegal. There's nothing that violates a law about diversity, equity, and inclusion. If the concept there is simply broaden the pot, broaden the areas where you're pulling in applicants and pulling in resources so that everybody's getting a fair shot. That's what I would say is DEI in a very, very simply put manner. Illegal DEI is accurate also, because where DEI programs become quota programs, preferential treatment programs, there's a very compelling case to be made that that violates Title VII as is. And if you've come to our firm for DEI training and advice over the years, I mean, we've been very upfront to tell people that Title VII doesn't allow you to prefer any race, color, sex, religion over the other. You've got to be neutral. But I think that in a kind of in an overzealous manner, some have taken that too far and put it into places where I would say it is illegal DEI already. And I don't know which of the two the government's going to go after. Is it going to be across the board? DEI is a bad word. You can't say it, use it, or do anything like it. Or is it going to be an enforcement paradigm based on existing law, that lens one I talked about earlier, existing statutory law? Okay. So what should you be doing? It's complicated. It's not a one size fits all approach. I mentioned that we've got sort of a multidisciplinary team approach. We've got checklist and template forms that we have available and others that we're developing. So just send me an email or something if that's something you're interested in. So let's break up who needs to do what. Federal contractors, immediately you're going to have to comply with the letters you're getting and these contractual revisions. You're going to have to untangle yourself from the 11246 obligations. So what are they doing? They're removing statements and policies, forms, notices, and documents that relate to DEI. You got to update your postings and your websites and the sub-identification from form solicitations. You got to consider risks of even self-identification. Is that something that you want to take a risk on? Consider the impact on talent acquisition, your ongoing business and recruiting issues. You update your EO clauses. You've got an awful lot of things that you've got to change quickly if you're a federal contractor. What if you're the private business like I am? 82% of us have got DEI practices. So here's what the feds are doing. I mentioned that earlier. The feds are going in and getting rid of all references to DEI, DEIA. Doesn't matter what name they appear, the federal government they're getting rid of that. So as a roadmap to what you may be asked to do, may want to think about doing, that's where I would look. What is the government doing? That's what I think they're going to enforce. Well, they're taking out the words. They're terminating all mandates, requirements, programs, or activities relating to any of these things. A new focus on the meritocracy. DEI officers are being suspended and terminated. We probably got a lot of those on the call today, but that's what the federal government is doing. Employee and resource groups are being suspended. Holidays are being suspended. Now, it's kind of interesting that they're saying suspend holidays, but at the same time, the president issued a proclamation about Black History Month. So, see if you can harmonize that. But, pronouns, another big, hot burning issue. getting rid of the pronoun things the government's doing. General, neutral, honorifics removed, self-identification, DEI programs suspended. They're reviewing position descriptions to see if there's any violation there within the government on these things. Closing initiatives in offices, taking down outward-facing media promoting gender ideology, turning off pronoun collections, canceling trainings. I mean, there's just everything that's on these three slides that I've run by real quick that the government's doing. I think you ought to consider that perhaps that's what the government is going to require the industries within its regulatory ability to do in the same way. And it's not a simple answer on doing that, right? There are a lot of things that are woven into the strategic plan and the operational materials of your business that tie into these things. So you can't just go in and gut it all very easily, I don't think. The other place I'd look is Stephen Miller. Stephen Miller is the Deputy Chief of Staff for Policy. I think he's the person in the Trump administration who's really driving a lot of this from a policy perspective. He's been with Trump since Trump won. He's a Duke graduate, for anybody that's from Duke on the call. Uh, but this is what he said he's focused on: getting rid of quotas, getting rid of preferences, getting rid of aspirational numerical goals, and reporting those. That's a key thing. He's very anti-reporting those. Says if you report those, you're preferring them. Uh, Getting rid of things like diverse slate rules, the Rooney Rule, where for every job you'd have to interview a minority candidate type of thing, supplier diversity programs, internships, fellowships, mentoring, business groups, affinity groups, leadership development, monitoring. We think those are probably going to be the hotter button areas within the scope of the government. And again, it could be the Department of Labor, it could be OSHA, it could be NLRB, it could be Department of Justice, it could be any of these government agencies with direct regulatory enforcement authority coming up with these. And again, because I think that's what they're doing internally, that's what they're focused on. So I think they'll expand the enforcement reach outside of their own agencies in the same direction. Uh, what do I think are probably low risk DEI activities? EEO statements. I mean, that's lawful. That's required. It's required under Title VII. I don't see the EEOC backtracking on that. EEO training. I don't see backtracking on that either. Policies that include everybody in the business. Parental leave for male and female. I don't see that being a focus. Listen. This is not legal advice. This is my educated reasoned speculation and what our firm believes, to the extent that 1,050 of us kind of believe the same thing. We pretty much agree on this: holidays, voluntary celebrations, certainly attorney-client privileged assessments of things are untouchable. Those federal district judges aren't going to permit inquiry into that. And I think that's sort of where most businesses are going to be headed right now. Going to be looking at these things under a privilege to figure out what to do. So your next steps to consider from my point of view is, think about a review of your DEI programs. Do it under a privilege so you can you can lay out on the table the good, bad, the ugly, and figure out where to go. Um, if you are a federal contractor or supplier, you've got immediate work that you've got to do. Um, you need to review your compliance obligations and your certification obligations, and I would suggest you do that attorney-client privilege. And I'm sure there's at least one of you here on the program saying, "Oh, he's a lawyer. He's just saying do it because he's a lawyer." That's not it. There's more work out there than we could possibly do. I'm telling you that because I care about your businesses, and your businesses want to do this assessment in a manner that you can protect the property and the rights of the business. And the only way you can do that in this type of a paradigm is to do it under an attorney-client privilege direction. You'll also get benefit from every lawyer out there is doing this type of thing if they're a labor and employment lawyer, and it's the type of thing we're all getting better at the more we do it. You've also got to stay on top of what's going to come down the pipe in the next 90, 120 days. Maybe I'm completely wrong. I don't think I'm wrong, but maybe I'm completely wrong. And all these things the federal government agencies are doing, they're not going to find a way to require you to do it. but I think they will, and I suspect that you all agree with me. Okay, so I didn't talk about immigration. The real change in immigration that we're seeing is the ICE kind of deportment sort of activity. Let me just give you a little context on that. So uh, we have a toolkit. In fact, we probably got it on our website, sort of what to do if ICE comes on your property. It's almost like what you do if the sheriff shows up at your property. Don't let them into private areas. Make sure they've got a warrant that's issued by a judge, not issued by the government. The government will issue its own warrants. They can't compel you to allow somebody into your business, but you usually want to require that first. And then you want to do it like the sheriff has come, or like if the Department of Labor shows up at the door. You want to put them in a room where they're not going to be too nosy. Maybe a room with nothing in it but a chair and a desk, and then ask them what they need and why. Make sure it's covered by the warrant, and kind of go that route. You want to not let them over. You don't want them to get out beyond the scope of their authority and require you to do things you're not required to do lawfully. Now, so that's what you do if ICE comes at the door, and that's the big focus right now from the new administration, new rules. I think what you've got to do as a business risk right now is you need to do I-9 audits. If you've got any concern whatsoever about whether your I-9 documentation is up to shape, you need to start looking at that. And of course, we can help with that. But that's where you are. I mean, they haven't come in and changed the H-1Bs or the other visa types. We're not dealing with that part of it. It's really the compliance obligations that you want to be airtight on. Now, I said I'd give you a little context on that also. Keep in mind in North Carolina, because I've gotten a lot of calls from businesses where their Hispanic employees are worried, frankly. What do we do? And I'm telling them, as of last week, I can't say it's true today because I haven't checked. There were only 3 ICE agents in North Carolina. So your odds of having one show up, at least as of last week, were pretty low. There's a limit. 3 people can only do so much. Now, will there be additional resources down the road? Probably, but the initial focus of the government in that area seems to be on the major cities, right? So you're seeing it in Dallas, Chicago, Los Angeles, New York, um, Charlotte, Raleigh, Greensboro, Winston-Salem, Wilmington. We're probably further down the list right now. So with that, if we can hit any questions in the next minute, or we're almost used up all the time, I see, but I'd be
Yeah, I
happy
think
to
what I might do, Bob, is
hit
just
up
about
questions.
5 or 6. I think I might just send them to you, and we can get them back out to
Sure.
people. It's mostly around Executive Order 1473. So I answered a few of them,
Yeah.
but there's several that I think it'd probably be better just to have you. We'll send it out when we send the recording out. Here's the answers to these 4 or 5 questions, since we are pretty much at time here. Wow, Bob! As always, what a great, transparent, open, and you're very good, very explaining the why, the how, the when, which is what you always do. So we appreciate you doing that. I think your message at the end was very good. Whatever you do, don't just ignore this. I think call your lawyer, call Ogletree, call Catapult. Either way, you need to get help now. Because there's a lot to this. It's not just anti-DEI and whether you're for or against that. There's a lot of things below that, for any company that you've got to be aware of. Otherwise, there could be some pretty steep financial. And Bob mentioned it, but to echo the point, the public social media, the public how you respond is also important. It's not just do these things. It's how you do them is important in this era of instant TikToking and Facebooking and whatnot. So again, reach out to someone, get help. There are a lot of resources here. Thank you again. We had a great session today. Great turnout. Look, as you know, Bob's firm Ogletree leads our employment labor law conference. Have done that for 30 years. We've got 2 coming up in several months in the fall here. So please, hope to see you there. And with that, we are literally at time. I'm going to sign off. Thank you so much. Look for an email coming out with the recording, with the presentation. So again, you can, if someone missed it, you can go back to it. And with that, have a great snowy, cold, icy day. Hopefully warm temperatures are ahead. Have a good day. Goodbye, y'all.
Thank you.